Just classic Susan. Just classic Susan, isn't it? You can go to lawandcrime.com to learn a little bit more of the top trending stories of the day. And again, great reporting by our very own Anthony Velez. Now, what you saw right there is actually a live feed into the Zachary Keene case, and what we believe is a postpartum expert, postpartum depression expert, is being called to the stand by the defense. We had a feeling this is an avenue that they might explore. And I want to talk right now with my very special guest. Before we jump in there, I have with me criminal investigator Charles Mittelstadt with us on the program. Charles, it's great to see you, and welcome back to Law and Crime.
Good morning, Jesse. Great to be on.
So as the case is starting to conclude, we're going to see some testimony from a postpartum depression expert, but talking about the postpartum depression of Cheyenne Harris, the mother of baby Sterling. And that's a weird avenue for the defense to explore because they keep putting the impetus on the mother, not so much Zachary Keene. I'm curious about your thoughts on that.
I agree, Jesse. It is sort of odd because we have seen the defendant in this case pile on. Everything that they've attempted to do in this case is involve deflecting any sort of responsibility. Just when you think he's about to accept some sort of responsibility, at the end of it, it's always ultimately deflected back onto the mother. So I find it curious that they would be sort of explaining her conduct in this case.
Yeah, we have a day of very interesting defense legal strategies, but hey, that's what we do here on Law and Crime. Now, I think we might be able to go live into that courtroom. So let's go live. Let's listen a little bit to this expert. Okay, I'm here with Charles Mittelstadt. Charles, this is pretty interesting, listening to postpartum depression, and maybe if Cheyenne Harris was on trial, the one that we're watching right now, it makes sense. But again, we keep talking about Zachary Keene putting the impetus on the wife. Have you ever seen anything, not even his wife, the person, the mother of his child, have you ever seen anything like this before in any of your investigations where the father of a baby who dies or is abused blames the mother?
I have not. This is a fascinating decision, I think, on the part of the defense to put this expert up. Again, it seems counterintuitive given what we've seen to this point of the defense's case and the absence of any responsibility taken on their part. So it's almost an attempt, it appears, to humanize the mom and, I guess by default, the defendant in this case. But he has essentially claimed this unavailability defense throughout the case so far, and so it's kind of puzzling to understand that. But listen, at the end of the day, the jury is going to come back to the horrific facts in this case and the terrible conditions under which poor baby Sterling suffered and ultimately died of malnutrition and infection, and it's hard to imagine that postpartum depression explains that away.
I mean, and you've seen situations before where babies are are brought up in a very tough life, but it doesn't always end like this.
No, exactly. I mean, I've been a part of many cases involving child neglect, and I've never seen a defense involving some sort of postpartum depression claim with these sorts of facts, Jesse. I mean, this is usually it's going to be some sort of very isolated act of neglect, but this is a much longer standing. I mean, this poor child, it was in his seat for what, 9 to 14 days, 9 to 12,
without the diaper
13 days.
Yeah.
And those are really extreme conditions.
Yeah, the worst of the worst. Here's what we're going to do. We're going to take a quick break, and when we come back, we'll be live in the courtroom more with that expert, and Charles and I talk a little bit more about this case. We'll be right back. Okay, let's talk this a little bit more, what we're seeing right now with Charles Mittelstadt. Charles, we're learning a lot from Michael O'Hara about the conditions of postpartum depression and what he believes there were certain signs from Cheyenne Harris, and including the difficulty of having 2 babies. I'm curious your reaction to what we're listening to.
I think the defense is going to regret this move. This, to me, has the potential of having tremendous blowback. I mean, the couple of things that I've already seized on, Jesse, is the fact that this expert is describing how Cheyenne would have had this lack of engagement and that others around would have noticed. And typically when that happens, others rally around her, which would have included Zachary. And so what we know is that poor Sterling has two human beings in this world that were supposed to protect him, his mother and his father. They both failed him miserably. And what this, I think the cross-examination of this expert is going to be brutal. He's going to be forced to admit that Keene should have stepped up, that all of the signs were there, and this was his opportunity to step up. And I think it's something that certainly members of the jury, if they're parents, can relate to, that when one parent is experiencing some sort of hardship, that the kids come first, and that's their opportunity, their obligation to step up, and he failed miserably. And I think it's going to be a problem for him.
In other words, what you're saying is, even if Zachary Keene couldn't detect the signs that something was wrong with Sterling, the fact that he could have seen the signs of Cheyenne should have been a red flag enough for him.
I absolutely think so. He should have. I think that is what the prosecution on cross is going to seize upon, is the fact that this is what this expert is saying. There are telltale signs to depression. Postpartum depression has become much more aware in the mainstream. There's been so many celebrities that have come out and spoken about their own personal experiences over the last few years. It's not something that's a less understood form of depression any longer, and it's not something to be ashamed of. And so as a result, I think the jury's probably well educated about the symptoms and the responses to that sort of depression.
Yeah, it's a serious condition, but is it a get-out-of-jail-free card for Zachary Keene? We're going to have to see. We'll take a quick break. We'll be right back. All right, let's break this down right now with Charles Mittelstadt. The prosecution doing a pretty strong job, I must say, with this PowerPoint of showing the aggravating factors. And in a way, they're thinking, look, we already won this. You know, we already won our case. We proved premeditation. We proved first-degree murder. So how do you think they're doing right now in the sentencing phase? Because this is a little bit of a different animal here.
I think they have a very compelling case as they've laid out in this PowerPoint, Jesse. You know, the defense tried to make this about state of mind, about Tremaine Wilbourn's state of mind in terms of being in fear of his safety. And they're essentially saying, no, the state of mind is absolutely relevant, but the state of mind had to do with his fear of being apprehended and reincarcerated, not the fear of his own life or his own safety. And so I think the presentation they're making and the mitigation factor, or the aggravating factors that they are highlighting, are powerful and very compelling.
You know, they're going to go through that and kind of undercut the defense's argument. Real quick, I know we have about 10 seconds. Do you think there's any mitigating factor that stands out for you?
It's hard to imagine, given that the one that they were hoping to pin their hat on was the one that was denied by the judge.
Yeah, that race-based trauma did not work out so well for them. Hey, listen, we're going to take a quick break, and when we come back, we have an exciting interview with Cesar Sayox, former attorney. Stay tuned. We'll be right back. All right, so as we listen to the defense's closing argument in the penalty phase, I'm back here with Charles Mittelstadt. And Charles, I can't help but think, yes, they are really stressing the human factor here for the jury to consider when ultimately they have to render the death penalty or not. But the reasoning, what he may have gone through in his life or suffering from depression or PTSD, I can't help but think that people that commit these kinds of crimes, isn't everybody going through something at some point if you're in a death penalty case? I mean, really, how is the jury supposed to separate this? It's not like, well, this is a very well-adjusted human being who made a choice. You understand what I'm saying? I mean, how much do these factors weigh in for the jury?
Well, obviously the defense hopes that they will resonate on some level. Again, it's a matter of trying to humanize this defendant and to give the jury something to think about in terms of what the sort of trauma that he may have endured up to this point. And you know, we also, when we have police-involved shootings, it generally comes down to a human factors expert who tries to explain what was going through an officer's mind just milliseconds before pulling a trigger. And so I think this is somewhat comparative. This is their best effort on the other side of that argument. But, you know, I think what they have to rely on is the fact that if you look statistically at juries awarding the death penalty, statistically, you know, it's awarded less and less since the advent of exonerations, and nobody wants to be part of making the wrong decision. So that's probably the best statistic they have on their side at this moment.
Hey, it's tough sitting on a jury, especially a death penalty case. Making that decision is really, really not something everybody can do. Let's take a quick break. When we come back, we'll be live in the courtroom. Hey, listen, I've seen closing arguments before, but I think that might have crossed the line. Charles, what do you think? And we know that one of the members of Tremaine Wilbourn's family was asked to leave the courtroom. I'm not sure if the same thing, I'm not sure what's happening right now, but we know that somebody from Wilbourn's family was asked to leave the courtroom. There's some excitement going on. Charles, what do you make of what's happening right now?
Wow, that was an impassioned argument made by the prosecution.
Okay, we're going live now. Sorry, Charles, there's something going on in court. Okay, a little bit of confusion right now. Apparently, Tremaine Wilbourn was yelling something in the courtroom. We're getting word about what is happening. We'll let you know in a second. But, Charles, these outbursts, what do you make of them? I'm sorry I had to cut you off.
Amazing. I assume that this is his reaction to the prosecutor walking up and calling him or describing this as the face of a coward. And perhaps he decided he wasn't going to take that laying down, so he has decided to excuse himself from the courtroom. But amazing turn of events here. I mean, this is a highly emotional case, as one can imagine, and
we're getting reports
really
that
fascinating.
We're getting reports that they're screaming out now in the hallway. And again, any kind of case is emotionally charged, but here with the death penalty on the table, you can imagine this is what's causing this. I mean, we're talking about the life of the defendant right now. Absolutely.
I mean, the stakes could not be higher for Tremaine Wilbourn, and this has to be as stress-filled a situation as you can imagine. And the prosecution has come out swinging here in their last licks in this case, and they've left nothing on the table.
You know, we can't forget the fact that Officer Bolton's family rejected Wilbourn's offer to take life in prison without the possibility of parole and extinguishing all of his rights to appeals in exchange for no death penalty. That was what he offered, and the family rejected that. They wanted the death penalty to move forward. So both sides are very emotionally charged here.
Absolutely. I mean, this is as tense a situation and a trial as one can imagine, and both sides are dug in, and this is what you get when both sides are dug in, and one is fighting for their life and the other's fighting for justice.
Okay, so if you're just joining us, there was some chaos here in the courtroom. First, the prosecution in the rebuttal argument basically went directly towards Wilbourn, was pointing at him and calling him a coward. There was an objection. Wilbourn got up and left and yelled and left the courtroom. Someone else was asked to leave the courtroom. There was yelling outside in the hallway. We have a short clip of this outburst in case you missed it. Wow. Okay, so Wilbourn called Alonda Dwyer, who you just saw yelling at him, a racist. Several of Wilbourn's family members leave the courtroom. And they called the prosecution a racist. Charles, what do you think?
Fascinating situation there, Jesse. I mean, that's I haven't been part of a trial where it culminated into so much tension and what actually seems like it could have turned violent. Or was very close to turning violent. Unfortunately, the bailiffs and the security got involved and took the appropriate actions. But wow, amazing.
Yeah, we are so happy that we have the bailiffs in there. And the question is, racism, calling her a racist. I wonder where that stems. But we can't also forget the fact that the defense yesterday tried to put in evidence of race-based trauma. They tried to bring in a clinical psychologist talking about how people in the African-American community experience race-based trauma after police shootings, and that was something that the defendant was experiencing at the time he shot Officer Bolton. That testimony was not admitted by Judge Coffey. Did you think that was a good decision?
Well, you know, I think it's a sort of decision that has huge consequences. It sets a precedent, and you cannot ignore the fact that Judge Coffey is black and has made this decision in the denial, and so with regard to the racism argument and claim, I don't know, how where that goes.
Let's play a little bit of that from yesterday, this race-based trauma, because it's something unique. We haven't seen it in a courtroom, and it became a novel issue of law, basically. Let's see how it happened yesterday in court. That was a witness the defense tried to bring in. Unfortunately for them, the judge ultimately ruled against that testimony coming in. And Charles, I just want you to note what the judge said. Judge Coffey said, I'm going to make this admissible. I'm not going to carve out a new segment of the law that basically says if you are a black male, you have the right to shoot a police officer, kill a police officer, and then say, I did this because I'm suffering from racial-induced trauma. Is that a fair statement?
Well, I think probably the judge was also taking into consideration the fact that this defendant as a convicted felon, has a prior violent felony conviction, and in the context of the applicability of that testimony to this defendant, that was an appropriate ruling, I think. And he went on to make sure that the record included the explanation for why he denied the admissibility of that testimony, and it included the fact that he was concerned about making this sort of testimony sort of mainstream in these cases. And
that may ultimately be an issue for an appeal, which would be something to consider. Here's the thing. Right now, we had a really huge development in court. In case you missed it, there was an outburst in the middle of the prosecution's rebuttal closing argument during the sentencing phase. Remember, this is the penalty phase. This is the last opportunity for the prosecution and the defense to argue in front of this jury regarding the death penalty. And watch what happened. What a day, what a day. What the judge is going to let the trial go on, and he's even said that in the past 12 years, he has never seen a defendant act so disrespectful during court proceedings as Wilbourn has been over the past week, refusing to stand, refusing to take the witness stand, looking uninterested and smug. Mr. Wilbourn does whatever he wants to do, and the prosecutor in this case, by pointing at him and calling him a coward, she did not incite him in any way. Charles, reaction to what the judge just said?
Well, I think it confirms that this prosecutor understood that. I think it's incredibly deliberate on her part. She understood that this judge felt personally disrespected by this defendant, and therefore she would have the cover to do something that I think under different circumstances would absolutely be considered to be inappropriate. And she went over there and she absolutely intentionally triggered him in order to get the sort of reaction that she got.
You think she purposely did that to get that reaction out of him? For him calling her a racist or something like that?
I'm convinced. To walk up to a man who's already been convicted of a previous violent crime and then the murder of a police officer, and walk within a few feet of him and call him a coward and essentially do so in a raised voice, if you can't anticipate that that's going to cause some sort of very negative and potentially even violent reaction, then I think that's would be naive.
And I guess it worked, because you know who saw it? The jury saw that. Now, Charles, thank you so much for coming on to talk about these cases. We love having your perspective, and you got to make sure to come back soon.
My pleasure. Thanks so much.
Okay, everybody. So here's what we're going to do. We're going to take a break. Obviously, we're covering a lot here today. We're keeping a careful eye on the Wilbourn trial. We're going to keep a careful eye on the Keene trial. But I will be signing out. But Vincent Hill will be signing in, and he's going to guide you through the next chapter of these trials. You don't want to miss anything. This is a very busy day on the network, and if today explained anything, you never know what's going to happen when we have those cameras rolling. We'll be right back right after this.